for
believe
decades.
the question.
I can't imagine you ever saying, bring me some of the boxes that we brought back from the White House. I'd like to look at them. Did you ever do that?
I would have the right to do that. There's nothing wrong with it.
But I don't think you would do it.
Well, I don't have a lot of time, but I would have the right to do that. I would do that. There'd be
All right, let me move on.
Remember this. Yeah. This is the presidential.
And that was Sean Hannity in an interview with Donald Trump. And Hannity's like, let's move on. But now Donald Trump has filed what may be the most frivolous motion to dismiss I think I've ever seen in my legal career in the Mar-A-Lago document case for Trump's willful retention of national defense information. Donald Trump just filed a motion to dismiss the indictment alleging absolute presidential immunity. Donald Trump claims that he designated classified records, highly sensitive information, government secrets, such as potentially nuclear codes, war plans, and other highly classified information. Trump says he designated them personal while he was in office, and therefore, by doing that, he should be entitled to absolute presidential immunity, and he's asking federal Judge Aileen Cannon to dismiss counts 1 through 32 of the superseding indictment, which involved the charges relating to violations of the Espionage Act. I want to break down what Donald Trump just filed, and I've been speaking to a number of prosecutors this evening, former federal prosecutors, former state prosecutors, and what I've been hearing over and over again from one person, for example, quote, "This is as outrageous as anything I have ever seen in my entire legal career," from veteran prosecutor after veteran prosecutor. Let's just take a look at this motion to dismiss the indictment, which is frankly not only sanctionable, but just what a horrific thing to claim that you can steal classified documents and claim that that's within the ambit of presidential authority to steal our national secrets. Horrific stuff. Let's go take a look at the introduction, then let's break this all down. Here's what it says. It says, President Donald J. Trump. I'm going to remove the reference to president because he's not that right now, but I'll just say Donald Trump respectfully submits this motion seeking dismissal of counts 1 through 32 on the basis of presidential immunity, as these charges stem directly from official acts by President Trump while in office. Specifically, President Trump is immune from prosecution on counts 1 through 32 because the charges turn on his alleged decision to designate records as personal under the Presidential Records Act and to cause these records to be moved from the White House to Mar-A-Lago. As alleged in the superseding indictment, President Trump made the decision while he was still in office. The alleged decision was an official act and as such is subject to presidential immunity. This court should hold a hearing to resolve any factual disputes relating to the official nature of President Trump's Presidential Record Act designation and the removal of his personal records from the White House. First and foremost, how brutally absurd to claim that you converted nuclear secrets, war plans, and other highly classified information into personal records. The Presidential Records Act says the exact opposite of what Donald Trump claims it says. It does not say that you can go and steal American secrets and claim that they're your personal playthings, like perhaps personal notes for an autobiography. So that's kind of the first and foremost thing that, stands out here. Secondly, Donald Trump then says that the court should hold a factual hearing. That's simply not what a motion to dismiss a criminal indictment is about. You have to accept the factual allegations as pled in the superseding indictment. And second, Donald Trump just misrepresents what the superseding indictment says. Trump goes, as alleged in the superseding indictment, Trump made this decision while he was still in office. That's simply, you think that special counsel Jack Smith said, Donald Trump designated the nuclear secrets as his personal records telepathically while he was in office without even doing anything at all. So again, these are bold-faced lies. This is as frivolous as you get right here. Let's go take a look, though, at page 16, where after citing, it looks like a copy and paste job of the other absolute presidential immunity brief that Donald Trump filed in the Washington, D.C. criminal case. Like, if you're confused, this is not what I'm talking about right now. Trump filed this absolute presidential immunity thing in the Mar-A-Lago document case, not the D.C. case we're talking about. We previously talked about the Washington, D.C. case where Donald Trump claimed absolute presidential immunity there to try to overthrow the results of a free and fair election, which federal judge Tanya Chutkan rejected, which the D.C. Circuit Court of Appeals rejected, which is now before the Supreme Court on Donald Trump's application for a stay as of the recording of this breaking news update. I'm talking about now in a case involving Donald Trump's theft of national defense information. He's claiming that that was official presidential conduct to convert our national secrets into his own personal property, and he's alleging it in this motion that he just filed. Again, you don't get much more frivolous than that. Here's what Trump says. This is page 16. Let's just read the filing. He goes, under these standards, Trump's alleged decision to designate records as personal under the PRA and cause them to be removed from the White House, which underlies counts 1 through 32 of the superseding indictment, was an official act by the incumbent president. As the Supreme Court held in Fitzgerald, absolute presidential immunity from civil liability includes all actions taken within the outer perimeter of a president's official responsibilities. Trump's decision to designate records as personal and cause them to be removed from the White House plainly constitutes an official act within the outer perimeter of the president's official duties, as discussed in more detail in Trump's separate motion to dismiss based on the Presidential Records Act. The Presidential Records Act specifically provides that during the president's term of office, the president shall remain exclusively responsible for the custody, control, and access to presidential records. The statute recognizes that the president shall categorize documents produced or received during his presidency as presidential or personal records. Well, you don't get to turn national defense information into your personal playthings. You don't get to act like a fascist wannabe toddler and go, me, these are mine, these are mine. These don't belong to you. These are not personal at all. This is part of a series of motions to dismiss that Donald Trump is bringing, as he mentions in that motion as well. He's bringing it based on vindictive prosecution under the Presidential Records Act as a separate motion. I want to go right here, though, to what Bradley Moss is saying. Bradley Moss is a national security lawyer and expert. And here's what Bradley Moss said. I think his insight is great right here. He goes, this is it. This is the grand Presidential Records Act legal theory that they've been previewing for 18 months. What a joke. Their argument is that Trump designated all the records as personal. He did so while president. No one can scrutinize how he did so, and therefore his possessions can't run afoul of the Espionage Act. What a crock. First, this is a motion to dismiss. You can't introduce facts, and that alone is fatal to this motion. Trump is stuck with the facts in the indictment, no matter how much this motion pretends otherwise. Second, his entire theory is based on turning the Clinton case. You know, they always talked about the Clinton socks case, the Clinton case into something it was not. Trump has taken the view that Clinton's case, by the way, which was a district court case, not even a circuit court case, that the Clinton's case means presidents can reclassify agency records as personal presidential records without scrutiny under the Presidential Records Act. That's not what the case is about. Clinton designated as personal audio tapes he himself created and that were never designated otherwise. the court declined to make NARA evaluate whether they should be reclassified. These records were originally agency records. If Trump wanted to reclassify them, he had to do so through a written process, which I guarantee he never did. And of course, that's a matter for trial, not a motion to dismiss. He goes on to say, and here is the other thing which I thought Trump would address, but does not. Let's say he did reclassify the records and just never shared the reclassification outside the White House. So what? Why would that then put them beyond the reach of the Espionage Act and national defense information? How does the PRA, the Presidential Records Act, insulate Trump from that statutory provision? Your guess is as good as mine, since his motion never addressed it. This motion is such a letdown. I was expecting a lengthy diatribe about the PRA's history, but this is nothing more than Tom Fitton's legal fantasy, and Bradley Moss believes Cannon will reject this easily. Look, folks, you never know with Judge Aileen Cannon what she is going to do here, but what I do know is the 11th Circuit will never let this argument fly. One of the things here that Donald Trump is undoubtedly trying to set up, though, is the same way the interlocutory appeal in Washington, D.C. to the D.C. Circuit stayed and paused that case. I think what Trump is trying to do here is set up an interlocutory appeal that will result in a stay of these proceedings to try to delay this case from going to trial. Ultimately, though, that may backfire depending on what the United States Supreme Court does, which may or may not create precedent to undercut what Donald Trump is doing right now. But the 11th Circuit is not going to countenance this at all. I think that even trying to file an appeal here, Special Counsel Jack Smith will certify it as a frivolous appeal, as a frivolous motion, but we'll follow the next steps. Wanted to bring you this breaking news right away. Donald Trump filing this absolute presidential immunity argument in the Mar-A-Lago document case, claiming that willfully retaining national defense information were part of official presidential responsibilities by taking classified information, converting it into his personal playthings, his personal documents. He claims that thereby makes it subject to absolute presidential immunity. That's ridiculous. To me, that's also treasonous and traitorous. And what a horrifying, horrifying motion. You heard it here first on the MeidasTouch Network. Hit subscribe. Let's get to 3 million subscribers together. Have a wonderful day.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.